Hello, my name is Tom Hagee. I'm with HB Litigation Conferences, working with LexisNexis today. I'd like to welcome you all to the LexisNexis complimentary CLE accredited webinar titled When Employees Tweet, Protecting Your Brand in Social Media. Before I introduce our speakers, I have a few announcements about today's event. This is for our phone participants only. If a problem arises during the program, dial *0 for the operator. For continuing education purposes, those of you listening by phone only, please make sure that you've identified yourself with the operator. If your name has not been taken, please dial *0 now, and an operator will take your information. Those of you listening by computer, you do not need to identify yourselves with the operator. I'd like to direct your attention to a survey which is available at any time during the presentation. It is in the bottom of your webinar screen in the pink area. We encourage you to complete the survey. Lexis is very interested in your thoughts about this program and would appreciate hearing what you think for future planning. In order to process your CLE, please download and complete the, quote, When Employees Tweet form, which you'll find in the gray CLE widget in the bottom dock of your webcast console. Please promptly return those forms as instructed to the LexisNexis CLE team. We suggest downloading these materials shortly after the program begins. Always please consult your local rules for guidance on CLE or contact LexisNexis at cle@lexisnexis.com. All attorneys joining us today will be given 2 4-digit codes randomly announced by me throughout the call. Please be ready at all times to write these codes down so you can enter them on the appropriate paperwork. These codes are required to receive your credits and verify your active participation, and you must attend the entire event in order to receive these codes. Again, all CLE material can be downloaded via the gray CLE widget in the bottom dock of your webcast console. The panelists welcome your questions. You can submit your questions by the Q&A tab of the webinar platform throughout the program. The panelists will try to address as many audience questions that are submitted through the tab as possible during the last few minutes. We'll reserve the last few minutes of the webinar to answer your questions. Please keep in mind we can't get to all of the questions due to time constraints. We cannot take questions over the phone lines. We can only take them through the chat portion. But we do encourage your active participation to make sure you're getting the information from our panel that you're looking for today. Now I'd like to introduce our speakers. These are brief introductions. There are more complete biographies included in the PowerPoint. First of all, I've got Chris Kalson. He's counsel in the Labor and Employment Group of Crowell & Moring in Washington, D.C. With respect to social media, Chris advises employers on developing, revising, and implementing social media policies and defends employers against claims by current or former employees involving social media issues. Robin Diaz is Interim Chief Legal Officer at St. Jude Children's Research Hospital in Memphis, Tennessee. In this role, Robin oversees the legal affairs, technology transfer, and government relations departments. She manages outside counsel relationships and advises on employment law, biomedical ethics, medical staff affairs, and general operational, regulatory, and transactional issues. Jessica Hodkinson is Legal Director of Labor, Employment, and Litigation at Avaya, Inc. In her role, Jessica provides day-to-day counseling to business leaders, human resources, labor relations, recruiting, corporate security, with respect to all labor and employment matters at Avaya, including but not limited to compensation and benefits and HR policies, including social media policies. Terry Stewart is an attorney in the Atlanta office of Fisher & Phillips, a national labor employment firm. Terry represents management in all areas of labor and employment law in state and federal courts, as well as before state federal agencies. So I want to thank the panel on behalf of Lexis for all of the work and preparation put into this. And with that, I'm going to turn it over to Chris Kalson from Crowell & Moring. Chris?
Thank you, Tom. And I would like to also quickly extend my thanks to, on behalf of Terry and Jessica and Robin and myself, to all of you who are listening in today. We hope you find the presentation interesting and engaging. We wanted to start off by talking very briefly about some statistics. We've all heard and seen the statistics about how prevalent social media has become in our society. I'm guessing almost everyone listening in has one or more social media accounts that they use to varying degrees. I myself have a Twitter account that I use for work and a Facebook account that I use to make inane observations about my life, post pictures of my barbecue adventures, view pictures of my friends' kids and pets. But as everyone also knows, social media has quickly invaded into our workspaces and creates a number of opportunities and a number of risks for companies in dealing with their own employees and the outside world with respect to social media. And to that end, I want to jump into some of these statistics. This comes from a very recent survey that was just released regarding the use of social media in the employment setting. Some of these are likely not going to be a surprise to you, but some are very well might open some eyes. In particular, I want to highlight that only 32% of employers were found to have a social networking policy in place. I should say that the survey was actually conducted in September of 2012, but the results were not released until the last couple of months. So the actual number of employers with a social networking policy may very well be higher at this point. However, this number still seems low given all the media coverage on these issues, and as you will hear today, the importance of having and implementing such a policy correctly. I also thought that the 66% of supervisors who are active social networkers are affected in the way that they think about a subordinate was interesting. I'll note that active social networkers includes those who spend 30% or more of their workday linked in some way to their social networks. In many ways, I thought that number might actually be higher given the intensely personal nature of many social media posts. It's hard not to have an opinion about someone, either positive or negative, shaped by what they say or don't say on social media. At the same time, I was surprised to see that as many as 64% of people consider the employer's reaction or potential reaction before posting to their own personal site, and 79% when it's a work-related post. With some of the, frankly, incredibly silly things people post on their personal social media sites, it's hard to imagine that many people actually make this consideration before they post. Finally, I want to point out the apparent correlation between those who are active social networkers and the belief that they've been retaliated against in some way. We could probably come up with a number of different theories as to why there appears to be this correlation. But I think the main takeaway here is that this is a troublesome statistic any way you slice it, especially when you consider the continuing exponential increase in people being active social networkers. Now, with that statistical landscape as a base, I think it's also important, we think it's also important for folks to consider the various laws that are impacted or by or may impact the use of social media. And for that, I want to turn it over to Terry.
Thanks, Chris, and hello, everyone. Very glad to be here. You can consider the laws that come into play in generally two different categories. The categories of the laws that are directly related to social media and how you post, such as state social media password laws or perhaps the Stored Communication Act law. And then there are the laws that have always affected labor and employment. And these are the laws that basically have given social media a new power that they didn't have before. And it's that what many people say and do and post on social media stays in a memorialized form and often ends up in litigation or claims related to the labor and employment laws that have always existed and governed the employer-employee relationship. So I want to take a few minutes to address each of these individually and provide a little bit of an example as to each of these and how they may impact you and your decision-making as an employer. The first is the National Labor Relations Act, and this is the act that essentially says that governs the terms and conditions of your employment and basically says that employees have the right to speak and engage in discussions about the terms and conditions of their employment, also known as concerted protected activity. This was the law that was implemented to protect unions and the right to unionize. But now it has an entirely new forum, and Chris is going to share more about that. Because often what employees would do before in the break room or discussing things that happen, such as their wages, or I can't believe my boss just did that to me, that wasn't fair, if they were discussing that in the break room, now it often ends up in a social media post that is there to stay, and often for employers to learn about where they didn't perhaps know about it before. States are becoming more and more active in developing and implementing new laws related to social media, most importantly focusing on password protection laws. So if an employee has a password that gets them into a private area of social media, it is often unlawful for the employer to request that password and for the employer to access those private sites. There is also the state privacy laws. The invasion of privacy law is an umbrella tort that covers many other areas, such as your standard invasion of privacy, wrongful publication of private facts, and those type of claims. An example of that is where an employer may learn something at work, may it be a supervisor, may be a co-employee, and then that information is published on a social media site for all the world to see. As an example of that, there was an employee that another employee shared information with about having an STD at work. Well, the co-employee posted that information on the social media site, and the other employee that the information was disclosed about was placed on notice and actually sued the employer for wrongful publication of private facts. The way that the employer was not held liable for that claim was by the fact that that particular employer did not allow access to any social media site while on work hours. So that claim went nowhere, but it's an example of how it can easily come to light. There's also the federal and state anti-discrimination and harassment laws. This is Title VII, ADA, all of these types of claims that have been around for years and years, and we've come to know and navigate very well. And the way that this comes into play, again, is through often these social media posts, whether it be just a venting or a playful remark, can sometimes end up in litigation as the evidence of some type of discriminatory or retaliatory animus. And the statistic that Chris mentioned earlier is directly related to that. There's also the Stored Communication Act, and that's the federal law that prohibits intentional authorized access of electronic communication. That's easily said and understood when you think about your standard hacker hacking in and getting in unauthorized access, places like a bank account or a social media site that's private and password protected. But courts have taken a broader view with respect to these claims. And as an instance of this, there was an employer where the employees had a private online blog to complain about work. A manager from the employer learned about it and asked for the password. It was accessed. An employee was terminated as a result, and there was found to be a Stored Communications Act violation. So it was the act of asking and requiring that you hand over the password, not just the actual act of violating the password-protected site itself. Then there's the GINA, ADA, FMLA, and HIPAA, often related to disclosure of private medical facts or a disability. It can often happen quite easily, especially when coworkers and managers are on a site. They might say something like, "Bob, I hope you get well from that heart attack you had last week," and perhaps that's something that they learned through the submission of FMLA paperwork or through HIPAA-protected documents. Also, with regard to FMLA, you can often see, and we'll talk about some of the pros of social media later, but an example of that would be you see an employee who's taken FMLA indicated that they are not able to work, and they're out at their favorite party or their favorite restaurant and bar every day that week. So that might be evidence for you to take action against a particular employee for falsifying information. Then, of course, there's copyright infringement, trademark and advertising laws, securities laws such as the new FTC regulations, and we will talk more about how that might come up in labor and employment context as well. Chris, next slide.
Hey, thanks, Terry. Chris, before you start, I want to read the first CLE code today. First CLE code is 4026. It's 4026. Thank you. Back to you, Chris.
Thanks, Tom, and thank you, Terry. We want to spend a few minutes talking about what's going on at the National Labor Relations Board. Terry mentioned that as sort of the first law, the National Labor Relations Act, and much of the news surrounding employment and social media issues in the last few years has been generated by the, what I would say, very active and aggressive stance taken by the National Labor Relations Board and its now former acting general counsel, Leif Solomon, in policing both employer social media policies as well as the use of those policies in disciplining employees. I first want to note that it's a very important point for those of you who may think the NLRB and the laws it enforces don't apply to you because you don't have a unionized workforce. In fact, as the NLRB will be the first people to tell you, the National Labor Relations Act provisions protecting an employee's efforts to engage in concerted activities for mutual aid and protection, what Terry referred to as concerted protected activity, apply both to unionized and non-unionized employers, including when those efforts use social media. The NLRB has clearly seen this world of social media as a way to increase its relevance in the last few years, especially now that something like only 7% of the American workforce is unionized. Some of the other news you might have been hearing, though, is about the turmoil surrounding the board. They were acting for a long while without a quorum of board members, and several circuit-level decisions, including the D.C. Circuit in Noel Canning and the Third Circuit in New Vista Nursing, threw out decisions by the board because the courts found the board members were appointed in violation of the Recess Appointments Clause. Those rulings potentially invalidate a number of the board's earlier social media-related decisions, including in the Hispanics United case, where the employer was found to have violated the law by firing 4 employees who posted a defense of their job performance on Facebook in response to a coworker's statement that she was going to tell the boss that the other workers weren't serving their clients. It also potentially invalidates the decision in Costco that found provisions of Costco's social media policy related to defamation were facially invalid. The Noel Canning decision is going to be considered by the Supreme Court this fall, so it'll be very interesting to see how that plays out and what effect it might have on those decisions and others involving social media. That all being said, as of early August, and many of you might have seen this, President Obama and Congress cut a deal, and the NLRB now has a new 5-member board consisting solely of confirmed appointees for the first time in about a decade. So they're back operating at full speed. At the same time, President Obama nominated for the NLRB General Counsel spot a man by the name of Richard Griffin. He had been one of the NLRB board members that the D.C. Circuit found was improperly appointed in Noel Canning. Mr. Griffin was selected to replace the acting General Counsel Leif Solomon, whose nomination was withdrawn. Solomon had been a zealous advocate of the NLRB's taking a stand on social media issues and had issued a number of reports regarding his office's various decisions on whether to pursue particular social media-related matters. Griffin's nomination is controversial, and it's unclear whether he'll be confirmed. It's also unclear at this point whether he will be as active as Solomon was on the social media front. But given his support for Hispanics United and Costco, because he was a supporting member of on those decisions, it's a safe bet that he would continue to toe the NLRB's current line on social media cases. Now, with all of that in mind, I think it's a safe bet to say that this upheaval in the end will not have a major effect on the board's views in social media-related cases. And that's because many of their social media decisions have been based on long-standing principles that the board has just applied to the use of this new technology. This is something Terry alluded to a minute ago, conversations that may have previously occurred in the break room or around the proverbial water cooler are now happening on social media. And the board is just going to continue to be active on this front. And employers are wise to keep abreast of what the NLRB is doing. To that end, we just want to quickly note a few recent decisions coming out from the board on social media cases. And the first one there, Betty Page, was a board decision from April finding the employer, which was a clothing store, violated Section 8A1 of the National Labor Relations Act by firing 3 employees after they carried their complaints first made in the workplace over to Facebook and criticized their manager. They had asked the manager before posting on Facebook to close the store earlier, as other businesses in the neighborhood were doing, out of the employees' safety concerns. The manager didn't do anything about it, so they complained to the owner, which led to the manager getting wind of it and getting mad at the employees. The employees took their concerns to Facebook, and one posted, quote, "Tomorrow I'm bringing a California workers' rights book to work. My mom works for a law firm that specializes in labor, and boy, will you be surprised by all the crap that's going on that's in violation." And I apologize, I was reading a quote there. The board easily found this was classic protected activity and that their firing violated the National Labor Relations Act. The next case, New York Party Shuttle, that's a board decision from early May, finding that the employee who was a tour guide was improperly denied guide assignments for posting to a private Facebook page that his former employer was, quote, a worker's paradise compared to his new employer, where there was, quote, no union to protect you at the new employer, and complained that paychecks from the company sometimes bounced. Now, the board agreed with the administrative law judge who had heard the case before that the company's contention that the employees' communications were not protected because they were libelous was actually incorrect, because the statements, though harsh, were largely true and therefore couldn't be libel. I want to point out a couple of other decisions here, in particular the UPMC decision. In that decision, that was an administrative law judge finding in part that the employer's social media policy was facially unlawful, where it prohibited employees from describing any affiliation with UPMC on social media. Basically, it prohibited employees from disclosing where they work. And the ALJ said that severely limited their ability to discuss the terms and conditions of their employment with others. I also wanted to point out Giant Foods. In that case, the general counsel, who was Leif Solomon at the time, decided in an advice memo back in March 2012 that wasn't made public until the last month in response to a FOIA request, that Giant's ban in its social media policy on employees taking any pictures or videos of the employer's premises improperly chilled the exercise of an employee's Section 7 rights. So they had a blanket ban that prevented taking any pictures or videos, and the GC said that went too far because they may be wanting to take pictures of what they consider safety violations, which would be about their conditions of employment, and that would be protected activity. So there's a lot of stuff coming out of the board. Now that the board is back at full strength, I think we're going to continue to see them be active on this front, and it definitely makes sense for everybody to keep on top of that going forward. I'm going to move on to the next slide. These are a few more cases. These all come from Leif Solomon's prior advice memos that I had mentioned earlier. As you can see here, there's some pretty harsh language in these posts, which is unfortunately not all that uncommon. I think the key here is that employees can say some pretty bad stuff before they lose protection of the law, if they can show those derogatory statements are part of an attempt to engage in concerted protected activity. In the first instance here, or I should say the second instance here, where the employee called her supervisor some very derogatory names, if the person was just hacked off because the manager yelled at her about her poor performance, then the post is likely not protected. The NLRB would likely see that as just an individual gripe. But since she said it was because she wasn't allowed a union rep during this investigation, that is something that is clearly protected by the National Labor Relations Act, and that brought it within that cone of protection. On the last one there, the liking of a status, some may think simply clicking the like button isn't really engaging in any sort of concerted protected activity. But if the full board is faced with such a case, I think they're likely to follow the advice of the General Counsel here and find that the act of clicking the like button is in fact a form of speech. There have been a number of cases that fall under a First Amendment analysis, which is obviously a separate analysis, but those First Amendment cases, which usually arise out of a public university setting, in those cases courts have been willing to find that the simple act of liking on Facebook constitutes speech, and it seems likely that concept would be extended here by the NLRB if they're faced with it. Now Terry's going to jump in and talk about a few things that are not actually protected activity to just give you sort of a different take on this issue. Terry?
Sure. The way I like to describe it to employers is if it is the equivalent of an online version of an employee walking into a room and yelling something to the effect, I'm going to set this place on fire, or I'm going to go postal and you're all going down, that type of vent out to a group with no banter and no discussion and not in any way related to a term and condition of employment, or could no way possibly be related to any type of term and condition of employment, then it's more likely that the board is not going to find that that conduct is protected by the NLRA. And just to give you a few examples, a newspaper reporter's offensive tweets about his crime beat including, "You stay homicidal, Tucson," "See StarNet for the bloody deets," a bartender complaining on Facebook that he hadn't had a raise in 5 years, which would have normally been considered a term and condition of employment. But then he went further and said that he was doing the waitress's work without tips, calling customers rednecks, and hoping they choke on glass as they drive home drunk. The fact that the particular bartender wasn't responding to posts and not engaged in any discussion affected the board's decision. And we don't know if he'd gotten a like or two perhaps, then it may have changed the board decisions. But the fact that he's wishing harm on others as well as customers is probably going to cross the line into unprotected activity. There's also making fun of mentally disabled patients on employers' residential treatment facility on Facebook, posting a picture of yourself flipping off the tomb of an unknown soldier at Arlington National Cemetery during a work trip was not protected activity. As a personal example, I have recently helped an employer with a termination related to an employee posting threats against another employee on a Facebook page. And the employee was threatening this particular employee at work, and it just also happened to be memorialized on the Facebook page of this other employee as well. So the employer didn't take action necessarily based on the Facebook page post. They took action based on the threat at work, but the fact that it was memorialized increased the evidence against the employee, and the likelihood of that being found improper from the NLRB is very, very unlikely. Next slide, please, Chris. I want to talk a little bit more about this in the social media context. The NLRB is generally more likely to find a violation if there's any type of discussion whatsoever. So if the employers are on an employee-shared blog post, if they're engaged in a back and forth, if they're clicking the like button, even though it may seem to be an individual gripe at first, it can quickly become a term and condition of employment where employees are engaged in concerted, usually two or more, types of activity. So if, as a word of advice when taking action against an employee in this type of situation, it's important to advise your supervisors and be aware yourself to think about these different decisions and what the board is finding to be protected and unprotected, and decide which side of the sliding gray scale is it on? Is it more like an employee just saying, I don't like my wage, and other employees responding, yeah, we should all get raises, which would definitely be protected? Or is it more like an employee walking into a room and screaming inappropriate things out and perhaps causing danger to others, which is definitely unprotected? So when you're making the decision, just do a risk analysis of where your particular case falls on that scale. Next slide.
Okay, and I think that leads us into sort of talking about the policies themselves. As I mentioned earlier, the NLRB has been active on both fronts in terms of looking at the policies in a vacuum without looking at any underlying activity, and also looking at the underlying activity and see where, if an employer has taken action against the employee, whether or not that was a violation of the law. But there, as I mentioned, there have been these cases where they've just looked at the policy themselves and said yay or nay whether or not this policy is valid. And that leads us to sort of the next two slides, which are a do and don't for crafting a social media policy. Either if you don't already have one, if you're in that 68% that doesn't have one yet, or you already have one and you're thinking about making some revisions to it. These might be some do's and don'ts as you do that. The first thing here is the mention of keeping it as narrow, any prohibitions on employee social media behavior as narrowly drawn as possible. That has been sort of the first and foremost point that the NLRB has made over the last several years in dealing with these cases. Vague terms without any explanation of what the employer is including in those categories have repeatedly been found to be facially invalid by the National Labor Relations Board. And on the next slide, I'll talk a little bit more about some of those terms. The next point is requiring employees to talk about who they are on Facebook in terms of giving a disclaimer when they're talking about work-related issues or company products. And we mentioned here the FTC guidelines and Regulation FD. Here I'd like to throw it first to Robin to talk a little bit more about the FTC guidelines and how, for instance, she's implemented them at St. Jude's. Robin?
Thanks, Chris, and good afternoon, everyone. Both the FTC and the SEC have addressed social media use earlier this year, and so we just want to make sure that everyone's aware of those guidelines. On March 12, 2013, the Federal Trade Commission released .com disclosures, which was a follow-up to a 2000 FTC report on online advertising disclosures. The theme of the updated guidelines was that online disclosures must be clear and conspicuous. And the FTC set forth 6 main factors to consider in making an online disclosure clear and conspicuous. The first, and from the FTC guidance, what appears to be the most important, is proximity and placement. The second is prominence. The third would be other distracting factors in an advertisement. The fourth is repetition. The fifth is multimedia messages and campaigns. And the sixth is understandable language. The FTC really emphasized the importance of that first factor, proximity and placement, stating that the closer the disclosure is to the claim to which it relates, the better. And so the FTC is essentially saying that disclosures should be in close enough proximity to the claims that they're qualifying. And one way to do this, if you're advertising online, would be to include both claim and disclosure on the same screen if possible. Chris, did you want me to go ahead and talk about Regulation FD as well?
If you'd like to, please feel free to do so. I'm happy to do it as well. So go right ahead.
I'll go ahead and get started, and then you can jump in if you'd like. On April 2nd, 2013, the SEC discussed the applicability of its Regulation Fair Disclosure to releases of information through social media. And Regulation Fair Disclosure, or FD, requires public companies to disclose material, non-public information to investors in a manner reasonably designed to achieve effective, broad, and non-exclusionary discretionary distribution to the public before providing that information to shareholders. So Regulation FD is essentially meant to prevent shareholders from having an advantage as a result of early access to what is material and non-public information. The April 2013 report applies the SEC's 2008 guidance for disclosures on company websites to social media disclosures and the social media environment, saying that before disclosing material, non-public information through social media outlets, companies should ensure that the social media outlet will be a recognized channel of distribution to investors. And one way of doing that is on the company website to reference those authorized channels so that potential investors might know where to go to look for that information. Chris, I don't know if you had anything to add to that.
Yeah, I'm just going to very quickly, I think you covered most everything. I was just going to very quickly mention this, for those of you who don't know already, this stems out of a decision that related to Netflix, where the CEO of Netflix had released in June of 2012 on his personal Facebook page that the company had streamed 1 billion hours of content in June 2012, and they hadn't made any sort of disclosure that he was going to be releasing this sort of clearly material non-public information on his personal Facebook page. And so that was sort of the impetus for the SEC to extend, to make it clear that these guidelines, the Regulation Fair Disclosure guidelines, cover social media as well. And so I think the takeaway here is if you are a public company that's subject to SEC's regulation, certainly a statement on your website, as Robin said, or disclosures in your 10-Ks, press releases, that you might very well release this sort of information through the personal websites of your officers or directors or other senior officials who are spokespeople for the company, is something you definitely should make sure you're doing if you in fact are going to release the information that way. I'm going to quickly mention here the last two bullets as well. As a labor and employment lawyer, I'm always going to get behind the last two bullets. It's very important to get counsel involved both in crafting and revising these policies and in using them to discipline employees. But here I want to throw it to Jessica because she has some very good ideas about how to handle this situation. Jessica?
Thanks, Chris, and good afternoon, everyone. I would just, as a labor and employment lawyer, also echo what Chris said about the importance of making sure that you have counsel in not only drafting and implementing the policy, but in any facts that may relate to discipline. But in addition to just counsel and labor and employment counsel, I think what's really important is having a cross-functional team as you develop and implement the policy. For example, what we do as we implement and consistently revise our policies as the laws change, we have a team that includes human resources, marketing, communications, IT, and not only labor and employment counsel, but also our IP counsel. And by doing that, we have very diverse perspectives and can make sure that we're caring for all of the issues, not just legal issues, but also business and marketing related issues.
Thanks, Jessica, and I definitely echo that statement. I always try to work across teams. Even though as I'm outside counsel, I always try to work with both in-house counsel, but then the other members that you mentioned, HR and IT, on these sorts of policies. Two other things I wanted to mention before we move on to the next slide. One thing that I haven't mentioned here in the bullets, but that I want to make sure is clear, it's okay in your social media policy, and Terry alluded to this earlier, it's okay to prohibit threats, harassment, bullying, discriminatory name-calling, those sorts of things in your social media policy. And in fact, I would strongly recommend including those sorts of things. One other thing, and I want to throw it to Robin on this one, given her work in the healthcare industry, is the protection of personal health information. Robin, can you tell the folks a little bit about how you address this issue in your job?
Sure. Certainly we deal with sensitive, legally protected information such as protected health information. And so it's important to make clear in your policy and in your education to staff that postings may not include protected health information unless the patient or a legally authorized representative signs a HIPAA authorization would be relevant in this context, and that communications with the individual whose information you're releasing should not take place, or whose information you have, should not take place in connection with a social media platform. We also inform employees that they should not friend patients or the relatives of patients on social media platforms, which is often very challenging. We're a pediatric hospital, and the staff do get fairly close with the families and often get friend requests from the families. So it requires a lot of ongoing education with staff to make sure that they understand that there are ways to politely decline those requests without friending patients or patient families on social media platforms.
Thanks, Robin. I want to quickly move on to sort of the don'ts. What we covered a minute ago was the do's, and I'd like to talk briefly about the don'ts. Sort of right off the bat, one of the things you'll notice as you look at this slide, the term blanket prohibitions appears at least 3 times here as I look at the slide. And sort of an overarching point on that, the National Labor Relations Board has definitely found that sort of blanket prohibitions on doing X, Y, or Z that are vague as to what they mean are going to be a no-no and facially invalid. So I look at the first bullet here, and to not use vague terms like confidential or disparage without providing explicit examples. I think this is where a number of employers have gotten into trouble with the NLRB for not doing this. You need to give concrete examples of what sort of, for instance, confidential information you're trying to protect. So if your policy says do not post confidential information, it can't stop there. It needs to say something like, confidential information here includes things like trade secrets, marketing plans, business strategies, customer list, pricing information, product and services information, research and development activities, company financial information such as profits, losses, and operating expenses. I want to note that that can't include salary information or wage information. Employees have the right to discuss their salaries or wages, both of themselves and others, if they're doing so as part of a concerted, protected effort. And so that's usually the case, that they're doing so to increase their wages. Want to move on to the forbidding from talking to media case down at the bottom here. I said don't have a blanket prohibition to contact the media. This stems from a DirecTV case earlier this year before the board. The board found such a prohibition to improperly prevent employees from talking about wages, hours, and conditions, which they again have a right to do. The better way that this could have been said is to make it clear that the company has designated representatives to speak on behalf of the company and will utilize those people to do so. And then throw in sort of the thing we were talking on the last slide. If you speak about the company, you're required to identify yourself as an employee and that the opinions you're expressing are yours and yours alone, not the company's, which dovetails nicely with the FTC guidelines that Robin talked a bit about. The last thing I want to mention on this slide is the note at the bottom about an open question about whether to include what's called a savings clause. And what I'm talking about there is whether adding a clause that explicitly states this policy is not intended to prevent the employee from discussing any matter through social media that's protected by the National Labor Relations Act. The former acting general counsel, Leif Solomon, said such a statement would not save an otherwise overbroad clause in a policy. However, the board itself left open the possibility in deciding the Costco case last fall. Thus, I would say it's a bit unclear whether such a statement would save an otherwise facially invalid policy. For now, it's probably best to include it with the understanding that you should make the rest of the clause as specific as possible to avoid the claim that it's facially invalid. I'd like to move on now. I think we'd all like to move on. We've talked enough about the NLRB. and move on to something that I think is happening a lot these days, and that's the use of social media in hiring and promotion decisions. And for that, I'd like to turn it back to Terry.
Right. So whenever you get that resume in hand or that application, it's often second nature to Google the individual and see what they're doing on their LinkedIn page, perhaps what they're doing on their Facebook page, as to whether they'll be a good hire or a bad hire. As we often say in the labor and employment context, 90% of your problems come from 10% of your employees, often which can be detected in early stages. For instance, gaps in employment history or vague responses on an application. And so social media can often be the tool that allows you insight into whether that is a good or bad hire. So it's very easy and often beneficial to do, and I think Jessica will talk about a little bit of those benefits in a moment. But I also want to caution everyone on the don't, so to speak, of recruitment, or at least that there's some issue with whether social media use in the recruitment process or in the application hiring process is appropriate and to what extent. If you think, for instance, for a moment of your recruitment efforts, many companies post job postings on their own site, but other sites such as Monster and these type of things. So it's becoming, I think, almost 90% of potential applicants are looking for their jobs through online sources. So it's natural to place postings in different sites. But if you think about where you're posting and what sites you're using, each of those sites has a potential demographic associated with it. So if you think about your typical LinkedIn page, your typical LinkedIn user is approximately 41 years old, making more than $110,000 a year. So if you're pulling just from that one place, you might get a workforce that is largely over 40 and in a protected category. The same is true for other types of sites, such as Facebook and Monster. All of them have demographics associated with them. So the moral of that story is to just be diverse and to think about what particular places that you're pulling from as to who your applicant pool may be. Also, hiring managers have a tendency to want to Google the potential applicants. And if you think for a moment of the anatomy of a Facebook page, you often have the individual's picture, or in a profile, so to speak, with their name, their birthday perhaps, their school, their religious affiliation, groups they're associated with. And if you have a standard, appropriate application, you're not asking things on the application such as what religious group are you affiliated with or how old are you. You're just asking whether you're over 18 and authorized to work in the U.S. So the use of these sites often brings in protected categories, and I think Chris is going to have a picture in a moment that brings this into light. You're inserting protected categories in the hiring process where they never perhaps would have been before. And one of my favorite defenses in the lawsuit is ignorance is bliss. The hiring manager, the decision maker, didn't know about the protected category when making the decision. It doesn't mean just because they do that all of a sudden it's discriminatory, but it inserts it into the process and it gives applicants or those who were denied the job maybe a leg to stand on in an EEOC charge and litigation, and it's up to the company essentially to disprove that it wasn't a factor. But I think more and more people are becoming used to the idea that what they say and do online could result in an employer, their current employer or potential employer, looking at it. It's also important, as we talked about with some of the laws that come into play, the password protection, the Stored Communications Act, that you don't want to do anything that gives the appearance of fake friending or using someone else's account to log into someone's Facebook page, perhaps that they're already a friend of, to find more information. It needs to be above board and generally approved on a higher level of if we're going to use social media as a company, how are we going to use it? Are we going to use one person to look at all of it, so we're doing the same searches on all the different people so it can be done consistently and appropriately? And that's really the best way to do it. Or are we going to train managers to follow those guidelines as well, just like we would a standard social media policy? So Jessica, I know you have some thoughts on how it can help.
Yeah, so I would just say that, and Terry, I think you covered this in part, which is, it's hard to avoid the use of social media in recruitment these days. There is a whole network out there that we can tap into through the use of social media, whether it is LinkedIn or, we do a lot of R&D recruiting in various message boards about R&D in our particular industry. And so we use social media in that way to tap into talent that is available on these forums that we may not otherwise be able to identify